My name is Jim Stanford. I'm economist and director of the Center for Future Work, which is our progressive labor economics think tank with offices in both Canberra, Australia, and Vancouver, Canada. I'm joining you from the Vancouver side of the Pacific. I'm on the unceded First Nations territory of the Tsleil-Waututh Musqueam First Nations, and I want to pay my respects to those communities for sharing their land with us. Um, this is really, if I can co-opt the term, Craig, a trans-Pacific partnership. We've got people joining this webinar from both sides. I've seen the list of registrants. It's a wonderful list. We've had lots of interest in this webinar from New Zealand, from Australia, from Canada, from the United States, and probably other places as well. And that's testament to the incredible global interest in what's happening in New Zealand with this new system of fair pay agreements that Craig is going to introduce for us. So just quickly by way of introduction, this is the first in what we hope will be a series of webinars by the Center for Future Work. We've been inspired by our partners at the Australia Institute, who've been running this fantastically successful webinar series, Economics of a Pandemic. And we thought, you know what, this makes a lot of sense. Pandemic or no pandemic. So we're kicking off the first of this series of webinars, which will take a deeper dive into some more kind of specialized labor and industrial relations topics. And we'll build an audience this way. So we're just thrilled that we could have the first of this series on such a topical and inspiring, really, idea, which is what's happening in New Zealand. So for those that signed up to receive updates when you registered, you will hear about our future webinars. We're looking at other great topics in the weeks to come, so stand by for those. Let's dig into this one. So I'm going to pass the baton to my colleague, Alison Pennington, Senior Economist with the Centre for Future Work in Australia. And Alison's going to chair our session today and introduce Craig. Alison, take it away.
Thank you, Jim, and hello to everyone across Australia and beyond, by the sounds. It's clear we are living in history, so to speak. We are, in a time of great crisis, and I wanted to extend some warmth and strength to everyone out there. And also applaud you for extending yourself into engaging in a really important discussion about the structures and the policies that determine the economic security of everyday people, which has been made very clear in the pandemic that the economic security of people will determine the ongoing course of the pandemic and how it is that we pull out of that and what our economy and what our people look like on the other side. Australia and New Zealand have actually a very strong shared history in egalitarian labour market policies. It's worth looking into the history of them and how it is that we've walked kind of side by side together for a long period of time and then went separate ways in the neoliberal period, being hit in different types of ways and at different paces. But what's really exciting is looking at the developments in New Zealand about turning the corner, I think, out of the neoliberal rubble, really, so to speak, of growing inequality, lowering share of GDP going to labour, less productivity flowing onto wages and our wages crisis, and the growth in insecure and terrible forms of work which don't allow people to build meaningful and secure lives. So this from this picture, which is one that is shared really since the 1980s, these trends in both Australia and New Zealand, this is where growing calls have come for the introduction of sectoral bargaining policies. And that's the capacity of workers to negotiate and bargain with an employer across occupations or industries or sectors. At this point in time, Australia and New Zealand have had enterprise level bargaining systems. Sectoral bargaining systems do actually exist in other parts of the world. They're very common in Europe, particularly the Nordic countries. And so where we have gone backwards with growing inequality and less labour share of GDP going to people, some of those countries have actually not gone backwards since the 1980s and have been able to maintain that flow. So the OECD are calling for sectoral bargaining. We know that large parts of the world with greater levels of equality, higher wages have these systems, but we didn't have an example of a system in the Anglosphere, in the market economies, until New Zealand. So we are really excited, and it's my great privilege to introduce our speaker for today, who is Craig Renney. And I'd like to tell you everything about Craig. He's the economist and he's the Director of Policy for the New Zealand Council of Trade Unions. Prior to taking in the role in December 2020, so that was last year, Craig spent 5 years working for the Honourable Grant Robertson in the New Zealand Deputy Prime Minister and Minister of Finance. He was the Deputy Prime Minister and Minister of Finance as an advisor. And then Craig then worked for the New Zealand Treasury, Reserve Bank, Ministry of Business, Innovation and Employment. And really what I think Craig's work career is showing is like the different ways that fair pay agreements have been advocated for in these roles across unions and government and administration. And where he is now is heading up the Centre for, is heading up as economist and director at the policy for the NZCTU. Craig lives in and works in Wellington and is originally from the UK, and sits on the tripartite Future of Work Forum, which is something that is an innovation of the Ardern government. So Craig, I'll throw to you, and we'd love to hear from you about fair pay agreements, how they came about, how they're working, anything you really want to share. And
Sure.
After you finished your presentation, way it'll work everyone at home is I'll ask a couple questions, and then we'll throw to you for any questions you have in the audience. If you could put your questions into the Q&A function, and we'll select them and ask them to Craig at the end. So Craig, we'll throw to you. Thank you.
Thank you, Alison. You've made the first few of my slides slightly redundant, which is great because it means it's shorter, my presentation. As well, what I'll do is I'll just try and share my screen now with you, and then hopefully you can see that. Without any further ado, a little about me. As described, my name is Craig Renney. I'm the CTU Director of Policy, an economist. The Council of Trade Unions being the peak body for trade unions in New Zealand. Prior to that, as advertised, I was an advisor to Grant Robertson for 5 years, and prior to that, I worked at the Treasury, MB, and the Reserve Bank. I would ask you please not to hold that against me during the rest of this particular presentation. And if at any point in time I use a phrase or a jargon that you want explaining, please just ask. A lot of this is designed to confuse. It's not necessarily straightforward. We're talking hopefully across many countries. And so if there's something that we do or say, please just shout out and we'll see if we can explain it. But first, can I just address the photo that went with this presentation? Love the photo, very dramatic. I was slightly taken aback. So I sent my wife this photo, and inside 1 minute, she replied with this photo. And all I'm going to say is that I've got more hair than Bruce, but I'm incredibly flattered. Thank you, Alison. And from now on, you're going to do all of my photo work. But with that said, let's get actually into here what we're due to talk about today. I want to talk about how we got here. There's a lot of people who've done a lot of work to get us to here where we are today, and they deserve some applause. And it's not just me or any one person. There's a lot of people, and we should go from there. I also want to talk about what's actually on the table. What actually is the FPA that's on the table, and what does it look like? And where do we go from here? What's next? What do we next want to do? And what are the potential stumbling blocks in order to get us to what should be a really good law? So first, how did we get here? There's been a long process in getting to this point, but you can point to two of the historical touchstones that have driven this work to date. And the first one of those was the work that Helen Kelly, formerly of this parish, formerly leader of the CTU until she passed too soon. In 2011, she spoke to the New Zealand Labour Party conference, and she outlined a situation that she wanted to deliver called extension bargaining, which essentially was a situation in which in companies that didn't collectively bargain, if you had collective bargaining taking place elsewhere in that sector or that area or that industry, then you would extend the collective bargaining into new companies or into those companies that didn't undertake collective bargaining. She said, where a union is dominant in an industry or bargaining collective agreements with employers in the industry, then the standards identified in those agreements would be extended through an industry agreement to other workplaces within that industry. This became the genesis of what we now call fair pay agreements. And that's really when it started 10 years ago, if not more. And if you go back, the other touchstone in modern times is the work that Christine Bartlett led in winning the pay equity case against Terra Nova. Now, for those of you who aren't New Zealanders or perhaps don't follow along with New Zealand law, Terra Nova was a pay equity case for care home workers who were being paid less than others in comparable industries. And what that case showed was that employment contracts, though freely entered into, could have outcomes that led to systematic unfairness and discrimination, in that a systematic solution, a fair pay agreement, was required to address that problem and that situation. And so those two things together really were the sort of the start and the genesis and the driver of a lot of this work. So in 2017, the Labour Party Manifesto set out, in conjunction with all the relevant stakeholders, develop and introduce a legislative system of industry and sector collective bargaining that allows unions and employers, with the assistance of the ERA, the Employment Relations Authority, to create fair pay agreements. This was the first time the public really ever got sort of that phrase, generally from a politician, that sets minimum conditions across the industry and so on and so forth. The leader at the time was Andrew Little, who was then the leader of the Labour Party, and he announced this in 2017, so not long before the actual election. And it was a real surprise because actually the idea of fair pay agreements hadn't been discussed much in public, or hadn't been discussed certainly by Labour Party politicians. But the fact that both Andrew Little, who was a former union leader, and the then workplace relations spokesperson, Ian Lees-Galloway, who was also a union leader, really helped get this across the line and really helped get it into the Labour Party manifesto. But there are lots of other people who helped in this process. Richard Wagstaff, who's the chair here, he, John Ryle, a whole bunch of other senior union leaders were really important in getting that agreement into the Labour Party manifesto. And normally what I would do is I would show you a copy of the front image of the manifesto at that point in time. The 2017 manifesto was never published because of the change of leadership. And so ironically, we think about the 2017 manifesto and the 2017 election as being about Jacinda Ardern, but actually all of this was done under the previous leader, Andrew Little. And as part of that commitment, we had a thing called the Fair Pay Agreements Working Group. And in 2018, it presented its conclusions. The party manifesto statement on the previous slide was its terms of reference. How would it deliver that? And it was led in a very unusual and very unexpected move by the Right Honourable Jim Bulger, who was a former National Prime Minister, National Party Prime Minister. And he was the person who in 1991 was responsible for the Employment Contracts Act, which did a huge amount to actually damage employment relations in New Zealand and reduce the role of unions and workplace power in workplaces. It was also tripartite in its makeup. So the working group included membership from unions, it included membership from business organizations, and it included memberships from academia. It made recommendations, which we'll get onto, but it was subject to much criticism from government officials when produced, and it must be said, particularly from the Treasury, who questioned whether or not any of its findings or recommendations were valid, or whether or not it was actually even necessary as a programme to address any issues in New Zealand. 2020 election came along and we had new political leadership. Same government, new Labour-led government, but we had a shuffling in the ranks of the ministers. And after the 2020 election, the new Minister for Workplace Relations was the Honourable Michael Wood. He, as a former trade union official himself, and he sought largely to deliver on the recommendations of the working group, and we'll come on to just what that means in a second. But he's also sought the delivery of a fair pay agreement in the real world, in life, by the end of this term of office, by 2023, which is an ambitious goal, but one that is hopefully achievable. So hopefully by the end of 2023, we will have something real we can all point to. Now, at this point in time, as the economist at the CTU, I usually make a long conversation about what's the economic case for fair pay agreements, but I won't do that here. Suffice to show you this slide. The purple line here represents labour productivity in New Zealand based back to 1979. We've had pretty much constant expansion in terms of labour productivity over the period. But the real product wage, i.e. the wage that workers are receiving, since 1991, if you look at the chart, the gap has grown larger and larger and larger. And the share of the pie received by workers from growth and from GDP has continued to decline. It's actually continued to get worse. And one of the key things that the government has tried to do in delivering fair pay agreements, or its belief in delivering fair pay agreements, is that in trying to undo the sort of to create those, we will help to close that gap. We'll help to narrow actually the gap between productivity growth and real product wage growth over the period. The government also considers that the economy, that wages for those at the very bottom have lagged, particularly against particularly high income earners, and highest earners in their wages increase at twice the rate of middle income earners over that period. Fair pay agreements are also a mechanism the government's trying to use to stop what it calls the race to the bottom. We've seen particular industries such as bus drivers industries in New Zealand, where the costs of competition have been increasingly passed on to workers in the forms of terms and conditions. And one of the things we're trying to do through fair pay agreements is to address that and to reduce that particular problem. So with all of that in mind, what's actually on the table? What actually are we discussing in terms of fair pay agreements? Cabinet's objectives for fair pay agreements is to improve labour market outcomes by enabling employers and employees to collectively bargain minimum employment terms that will be binding on an industry or occupation. So they don't necessarily cover sectors, but they do cover industries or occupations. However, the proposals the government has agreed to consult on and deliver on don't quite follow the full proposals of the Fair Pay Agreement Working Group. And we'll talk about the gaps of that in just a second. So what is an FPA? An FPA is just simply an agreement across an industry or an occupation. An FPA is a baseline. It creates a floor for pay and conditions beneath which in that industry or occupation you could not fall below. It does not inhibit collective bargaining. You can still collectively bargain or secondary bargain for issues that are not in the FPA or to improve on levels that are set out in an FPA. You can't go on strike for an FPA. You can't have industrial action for an FPA, but you can go on strike for collective bargaining. So there's a lot of things in that, but essentially it doesn't inhibit the ability of workers to actually conduct collective bargaining. It's legally binding on all employers within coverage, all of those who are identified as being either in the industry or having employees in that occupation. And it creates two types of term that are then negotiated as part of the Fair Pay Agreement negotiation. The first of these is the mandatory to agree. And these are things that both sides must agree and must be contained within a fair pay agreement. The second group, mandatory to discuss, must be discussed and discussed with the principles of good faith discussions, but they're not necessarily mandatory to agree inside the proposals. And that's a real bone of contention, because we'll come on to what those actually are in just a second. If those terms can be determined by the Employment Relations Authority if negotiations are frustrating. So if one side simply says, I'm not going to talk, I'm just going to walk away, I don't care who you are, then the ERA can be called in to say, okay, we're going to settle that element. We're going to create a determination for that so that the overall negotiation can move on. And it's also really important to point out what it's not. An FPA is not a maximum. It doesn't mean that you're all going to be paid the same. It means that there is a floor for pay and conditions. It doesn't prevent employees negotiating with employers over issues. Employees can negotiate over any issue that they want. They can include anything that they want, but nothing in the FPA stops you from negotiating anything other than going below that floor. Importantly, it doesn't currently include contractors in the scheme or the self-employed. Work is currently underway to rectify this. It's an established issue, but such as the complexity of New Zealand employment law in this area, there is a body of work currently being undertaken by government, which is called Contractors Reform, and we're awaiting the outcomes of that Contractors Reform before we put contractors into fair pay agreements. But the expectation is that that will report and will have been concluded, so that by the time the first fair pay agreement comes into force, it should include contractors in whatever capacity is decided by that contractor's piece of work. Finally, this is really good, but it's certainly not going to solve all of New Zealand's workplace relations problems overnight. It's a big step, but we're not quite there yet, and there's plenty to do. Now, I know you're still asking yourself, so what's actually in an FPA? What does it do? And so what I've done is I've dug deep, and I've got MB's easy to read summary, and I am not joking, this is genuinely their diagram. Now you can try and read this. Now, for those of you who are less keen on puzzles than MB, what we'll do is we'll try and walk through the process as to how we're actually getting there. So in terms of initiation, how do we start an FPA? Only unions can initiate an FPA by meeting the representation threshold of 10% of the workforce under coverage, or 1,000 workers, or a public interest test. And a public interest test is one based upon the criteria of either low pay in the sector, low bargaining power in the sector, a lack of pay progression in the sector or industry, or long or unsocial hours that is not adequately compensated for in a contract. Now, I'll wait to see actually how this plays out in the real world and whether or not actually how the public interest test is actually really interpreted. But the threshold is a lot lower than I thought it was going to be when it was first established, and that's really good. It actually means there's a really low hurdle to actually get into that particular area, into a fair pay agreement. The initiating union or unions, because they can work together in initiating a fair pay agreement, must decide which work they want covered. It's not by somebody else. And if there's an overlap in coverage between FPAs, much like Australia, it's the better off overall approach. So you've got two FPAs that exist, and you're better off under one, then you get the better off term. Penalties will be applied to employers who try to avoid FPA coverage by misclassifying employees as contractors. So one of the things we're really keen to do is to make sure that nothing we do here creates an environment in which there is an incentive to move people to non-standard work. In terms of notification, everyone has a role. Employers, unions, business representatives, and government have a role in making sure everyone is aware of the commencement of a fair pay agreement and to reach as many of the affected parties as is possible. In terms of the process, unions will represent employees, and it's only unions. Employers will choose representatives who meet specified requirements. The bargaining sides must use best endeavors to represent all of those fairly, those who are members and not members through an FPA, and to ensure that Māori interests and views are effectively represented, because we're all T3T partners here. All FPAs must include certain topics that are mandatory to agree. These include wage rates, ordinary hours, overtime, and penalty rates. Some topics must be discussed, but don't have to be agreed. And those include redundancy, leave, health and safety, and requests for flexible working. Interestingly, the objective of a fair pay agreement, what the objective of the fair pay agreement is, a mandatory to discuss, but not mandatory to agree element. And so you can have a fair pay agreement, but you can have both sides disagreeing on what its objective is. And this is a lot less than satisfactory. To be frank, the idea that leave and health and safety aren't agreed between employers and employees in New Zealand, is not really acceptable as part of a fair pay agreement, and really should be core and center to its work. Now, there's a number of inbuilt flexibilities in the proposed FPA. An FPA can be exempted for businesses that are in significant financial hardship for a limited period of time. And our expectation is that that exemption would only commence at the start of an FPA rather than during the life of an FPA. So a business couldn't come along 6 months after it started and then say, we're going broke, can we just please be exempted from the current grounds of the FPA? An FPA, unlike Australia, as I understand it, can set regional differences. So you could have an Auckland rate for bus drivers, or you could have a Wellington rate for public policy professionals, or you could have a so on and so forth. Other employment terms can be included if the bargaining sides agree, and anything can be included as long as it complies with the Human Rights Act and minimum employment entitlements. So we can't have an FPA that would set you below the minimum wage. An FPA can also set, helpfully, a preferential payment for union members up to a maximum value of their union membership fees, which simply reflects the fact that union members are paying their union officials for the pleasure of actually doing all the negotiating work, but everybody benefits from the end outcome of that in the FPA. In terms of support, the government at the bargaining sides will be supported by training and a government-provided bargaining support person, a facilitator. The government will also contribute $50,000 per bargaining side for FPAs. Funding for this, however, is only based upon 4 FPAs in a year. So there might well need to be some rationing and prioritization of that money when we first open the doors and ask that question. The New Zealand Council of Trade Unions and Business New Zealand, as the umbrella bodies for unions and for business organizations, are also being provided with some funding to provide coordination roles in that space to do the job of how do we make sure our members know how the system works, how do we advertise where FPAs are currently in force or what they should be doing, and how do we do education and development work with our members and centres. So we're provided with some cash for that. Employees will receive direct updates from unions, which is a big thing in New Zealand, unless they specifically opt out of communications. Employees must be allowed to attend a two-hour paid meeting for the purposes of discussing FPA bargaining and for ratifying an FPA bargaining agreement. Unions can visit workplaces on FPA business without needing the employer's consent. That's currently not the case in New Zealand. You require employer's consent to access a workplace in New Zealand, but it can't be unreasonably withheld under the current law. However, what actually unreasonable withholding of it is a moot term, and as a consequence, it's often, how can I put it, reasonably withheld on unreasonable bases. And so this is a really big step. The only thing here is that doesn't apply before an FPA. So you can't access a workplace to organize the 1,000 votes or 10% of the workforce that you need prior to the FPA being negotiated. And if bargaining parties encounter difficulties, mediation will help resolve them, and then the Employment Relations Authority can also make recommendations and determinations. If the bargaining parties reach a complete stalemate, the Employment Relations Authority will set the FPA terms by determination. So if all else fails, it all flows back to the ERA to actually set what's going to be in the FPA, which is much more akin to what occurs in New Zealand, sorry, in Australia. Once agreement's been reached between the bargaining parties, the Employment Relations Authority will then vet a potential fair pay agreement to make sure that terms are lawful before it goes to a vote. And an FPA will need support from a simple majority of both sides. So on the employee side, that's simply one person, one vote. If you're in coverage, you get a vote, and if 50% plus one passes, it's passed from the employee side. On the employer side, it's slightly more complicated because there is a weighting on votes for small businesses, so that those employers with fewer than 20 employees get marginally more than one employee, one vote. And this is to reflect the fact that the government's simply trying to make sure that small businesses don't feel swamped by the effect of a single large employer in a particular area. If the first ratification fails, it goes back for renegotiation. If it then fails a second time, then the FPA sets it and it doesn't go for a third ratification. It is now just set. So you've got two chances to set it by bargaining. And on the third round, the FPA will be set by the Employment Relations Authority and then will just become live. Once finalized, the Ministry of Business, Innovation and Employment will make secondary legislation to bring the FPA into force. So it will apply to everyone within coverage. It will become the law of the land, and that people within coverage can enforce their rights through standard employment dispute resolution systems. And in addition, the Labour Inspectorate can or will enforce certain items of the FPA. And again, I want to come on to that just for a second, because they're not planning, as we understand it, to enforce all of an FPA. And we may well all end up in court again, rather than it being actually enforced via the Labour Inspectorate, which is an arm of government. In terms of the key differences with Australia, we have modern awards in Australia are an administrative process, as I understand it. They're not bargained outcomes. FPAs are bargained outcomes. The Fair Work Commission has complete control over the process, and parties submit to that. In New Zealand, it's the other way around. The parties have control over the process and, if necessary, submit to the Employment Relations Authority for a final determination. The process for any amendment of any modern awards is largely straight driven, whereas any FPA amendment will again be a bargained outcome. So again, once they're in force, it requires the bargaining parties to change them, not simply another party who's holding the FPA. Modern awards don't die. They just simply stay and hang around, whereas FPAs are expected to have an expiry date, and that you will have to renegotiate them if you want to continue them to be alive and refreshed on an ongoing basis. Enforcement in Australia is via the Fair Work Ombudsman, and FPA enforcement here is a bit unclear. So, we're having to work our way through that. And I think, one of the things we don't want to end up doing is paying, and forgive me for any lawyers who are on the webinar, paying lawyers lots and lots and lots of cash in order to work out something that we should have been able to work out in the first place because it's a piece of law. So where do we go from here? What's actually next in terms of the steps? Now, if we assume the Fair Pay Agreement bill enters the House later this year, which is the Minister's intent, then we'd have a 6-month select committee process, which is the Education and Workforce Committee here in New Zealand. At the end of that process, we'd have third reading and royal assent. It is anticipated that this legislation will be complete in 2022, and FPAs will essentially open up for business in 2022. That is assuming we get the first FPA agreement. It takes less than a year to deliver from commencement to end. This would see an agreement in place by mid-2023, which would deliver on the Minister's ambitions at the start of this presentation. We expect lots of unions will seek an FPA, but that a sector with a highly identified need, okay, bus drivers, supermarket workers, security guards, might well be the first to actually get through the system. I'm not trying to put names to things, it's just there are highly identified needs, highly coherent workforces in some of these spaces, and it should be much more straightforward in those instances to establish and deliver a fair pay agreement. but there's still plenty to do. For FPAs to become the kind of legislation we can all be proud of, then we need a few things. Contractors absolutely must be included. The failure to include contractors would just lead to a huge increase in contracting in the workforce and opting out in the workforce. And that's exactly what we want to avoid generally. And it's what, you know, one of the things this government is very keen to avoid. The areas that are mandatory to discuss really should become mandatory to agree. There's not really, it's not really fair to have two parties where there may be a massive power imbalance in the bargaining negotiations, where one of them has the right just to say, I disagree, I'm not even going to talk about this. And that's my mandatory to discuss over. Now, hopefully we're getting there, but, you know, I don't see why health and safety in particular, or leave or retirement, shouldn't be things that can't be agreed through a fair pay agreement. Enforcement by government is essential, and the fact that the Labour Inspectorate seems to be only keen to enforce parts of this is deeply problematic. And we really should be enforcing all of this process and every element of it. This is indeed law. We shouldn't be writing law for it not to be enforced. And as discussed earlier, we really need to get access for the purpose of organising support for an FPA to be included in the process. Otherwise, it'll be really easy to talk to employees, but only once you've got an FPA. And in order to get an FPA, you need to talk to employees. And so you'll end up with this chicken and egg situation unless you provide a situation in which unions and others can actually organise support for an FPA without having to clear it through an employer. Just as a quick final note, just between us and the however many people there are on the webinar across however many countries, whisper it, but there's actually a quiet revolution going on in industrial relations in New Zealand, which alongside changes in the economy present a huge opportunity for the union movement. We've got fair pay agreements, we've got contractors reform, which will hopefully see an end to the Uberization and the platform working and the gig economy type activities that we've seen more and more and more of in New Zealand and around the world. We've just extended sick pay from 5 to 10 days, and we're hoping to improve the law even more. We're in negotiations with the government and discussions with the government about creating social unemployment insurance. So that will be a state-backed redundancy protection for everyone, paid at a proportion of your wage, as a consequence of no-fault redundancy, and hopefully no-fault health coverage as well. So if you lose your job because of a health condition, again, you'll get income support at a level that exceeds the minimum welfare state, and is much more akin to your standard of living before you entered the system. The opportunities for unions to organise on the back of this transformation, on the FPA transformation, is enormous. And we're especially in sectors that we've not seen union growth for in years. In the private sector, we'll be able to properly organise and develop minimum standards of pay, terms and conditions in areas where union density is extremely low, if actually not non-existent. With a strong economy and low unemployment forecast, we're now at 4% unemployment in New Zealand, and the forecast to continue to decline from there. Hopefully, we've never been better placed to grow and deliver better conditions for workers. Now, I'm going to stop there. As somebody famous once said, I think we should say, let's do this. Let's get this over the line. And I'm really happy to take any questions.
Thank you, Craig. That was a brilliant and very clear overview of FPAs. And I think for everyone in Australia, and in our own countries, we can sort of see the way our systems would interact with something like this as well. I thought I would kick off with questions. And for me, I'd really like to turn your brain to the question of pay equity and sort of the gender lens on this, because the failure of enterprise bargaining systems is absolutely intricately tied with the introduction of women into the paid workforce, because as they came in, they took more likely to be in low paying, insecure roles, and often not in a position to have the security to bargain, but also access to bargaining infrastructure overall. So I know that in New Zealand, there's been the development of pay equity bargaining. And I wondered how this new system of fair pay agreements may interrelate with the existing one. Will they feed into each other? And overall, what do you see the possibility and opportunity of working women and their unions through fair pay agreements to boost their wages and achieve pay equity?
Sure. I mean, it's a really important question, and and the work that's been done by the trade union movement and others in New Zealand in creating the conditions in which pay equity payments and recognition can be made is hugely important and hugely valuable. It must be said, pay equity is actually still only a public sector phenomenon in New Zealand. The only cases that have really taken place are largely in those which are either paid for by the state or where there's a large state contribution in terms of the cost. We haven't really yet seen any significant private sector pay equity claims or pay equity payments. But fair pay agreements provide an opportunity to make sure that there is a common floor below which nobody can fall in an occupation or an industry. And so what that does is it creates a level playing field for pay. You now can't pay somebody less than that. You can't transfer the costs of competition onto those workers. And as often as not, over the past 2 years, so as often as over the past 20 years, the costs of those of competition have fallen onto those workers, and those workers in a lot of industries are overwhelmingly female. In the care industry, the costs of competition were passed on to workers because that's where you could move your costs much more quickly and effectively than the cost of the building or the heating or something else in the structure. And so that's where the costs went. And so that's why wages never kept up with with terms and conditions in that space. So fair pay agreements provide an opportunity to really make sure that we're actually we're creating a level playing field for both men and women in our space. Now, what that means is you're still going to have female dominated workforces and you're still going to have male dominated workforces. And that's where that pay equity can then interact, because if you've got female dominated workforces that have a fair pay agreement, that even though bargained fairly is still systematically discriminating against them, then pay equity then shifts the needle, because pay equity is about demonstrating that in that workforce the very presence of a large body of female workers is leading to unequal outcomes. So they complement each other, and hopefully over time we'll be able to make sure that actually these two things support and deliver pay equity both across the public sector, but also in New Zealand, importantly, across the private sector.
Great. I wanted to ask about something that is a great bugbear for labour advocates in Australia, is the fact that we have a system of full legal protection for free riding, in that our enterprise agreements are paid for and funded by a minority of union members in any workplace. And then something people may not know at home is that New Zealand actually has union-only agreements, which is that unions have the key role in bargaining collective agreements and represent members in that process. The agreements will cover members, which enables unions to be able to go out to a workplace and say very clearly the value proposition is if you join a union, you're going to be in a better position. And that's very difficult to do in Australia. I wondered if you could outline how that existing system of I guess you call it union monopoly and collective bargaining will interrelate with the new fair pay agreement system.
Yeah, I mean, you've hit upon a real sore point, to be honest, because essentially we're going to be moving to a situation in which you will see free riding, where somebody can benefit from the cost and the time and the effort that one of the bargaining parties, the trade union, has put into place in order to actually lift everyone's standards of terms and conditions of work. But in the slide deck, there's a little slide that talks about you can make a payment to trade union members to reflect that. So you can still, in a fair pay agreement, pay trade union members up to the value of their membership fees for the fact that actually they're contributing through their fees to that process. in a way that somebody else isn't. But you're absolutely right. We're going to move to a world where everybody benefits from, something that the trade union does. I personally don't have a problem with that. I think, there's a public good value in a trade union, and trade unions doing public good for public things, but we're making sure that trade union members aren't being financially hit by that. They'll be able to be compensated for their contribution as part of their fees paid to the trade union.
Right on. Okay, so we will move to, we've got quite a few questions coming through from participants. So we'll go, Heather has asked, and also Wayne McMillan has asked the same question. What is the union membership density in New Zealand? And maybe because these are quite short questions, Tina wants to know how often are FPAs going to be reviewed and updated? You did mention that they will expire, but I guess maybe you could go into depth about what the system of dealing with expiries might be.
Sure. Trade union membership, since the start of the Employment Contracts Act, frankly, in New Zealand has fallen off a cliff. The Employment Contracts Act removed the role of unions in most pay negotiations or in most employment relations situations. And so it fell from a level that was comparable with Australia in 1991. And now trade union density across the entire economy is 19.5, 20% in terms of the total union density. Now, there's a big difference between the public and private sectors. Public sector has a much higher level of trade union density, and in the private sector, it can be as low as 10 or below that in certain sectors. So, but 20% overall is the NZ figure. In terms of expiry dates, it's anticipated that because we're still waiting for the final legislation to come through, it's anticipated that we would see something in the order of 3 to 5 years as the life of an FPA, and an FPA can be dynamic. It isn't just set and forget. It can be set, and then it has elements within it that increase every year with inflation or another adjustment or something else in each year. So you don't have to wait 5 years for another pay rise potentially. But at the end of that period, we're still awaiting to find out what actually is likely to happen with how do they die? Do they just end and then they fall off a cliff? Or is it like collective bargaining currently in New Zealand, where they end and then you've got a year before they end? Or do they just carry on in perpetuity? Now you can guess which one we would prefer. But when they end, and the process of amending actually just creates real incentive for trade unions to go back in, start renegotiating them nice and early with employers, and to help actually build a base inside workplaces to make sure that we're constantly able and constantly having a conversation with our members and with employees in that sector, so that we can keep delivering these as we need to, without them ever really ending, without them ever falling off a cliff, so that there's a new one ready when the old one expires.
And for Australians at home, will know that falling off a cliff is a great weapon that is used in our industrial relations system at the moment to send us back to award conditions in the event of agreements expiring. So we've got quite a few more questions. Celia is asking, what is the composition of the Employment Relations Authority? That is the authority that is deciding if the public interest test is being met, and who will be part of it? The
Employment Relations Authority is an existing body. It's public servants. It's established by the government, and they are independent public officials. They're not trade union members. It's not a tripartite organization.
Okay. Peter, who's from Morris Blackburn Lawyers in Australia, a big workplace law firm, is interested in the additional piece of work that's happening regarding the reform for independent contractors. He asks, can you tell us a bit more about that? Where do you think that will land in terms of the definitions for who is a worker, a contractor, or an employee? And what's your best guess as to how or if contractors, especially in the gig economy, will end up being incorporated into the FPA process?
You can tell he's an employer from an important town, because he asks the big questions. In terms of where do I say that? It's far too early in the process to be able to give you any kind of degree of definitive about what actually is going to happen. There's been a lot of talk in a lot of places about creating a third type of employee, which would be a dependent contractor. But equally, there's a lot of pushback from that in terms of why would you have a third type of employee? A dependent contractor, i.e. a contractor who is solely dependent upon an employer, is an employee. They're not a dependent contractor. So, we'll have to wait and see where that work ends up. My best guess as to where that ends up is that if we have a third term, they will be treated as employees for the purposes of a fair pay agreement. So if you have somebody who is an Uber driver and essentially, or other services I'm sure are available, or they have something else that they're currently working with as a sole employer, then they will be required to be allowed to receive all the benefits in terms of the terms and conditions of the fair pay agreement that exists in that area, rather than them having to be outside that because they're self-employed.
They come in thick and fast, Craig. You're doing a great job. Mark Rollinson, who is joining us from the United Steelworkers Union in North America.
Can I send my regards to the United Steelworkers of North America, and my condolences for the recent loss of Richard Trumpka over there, who's been very dearly held in our hearts over here.
Thank you. Mark would like to ask you if he understands correctly, after two attempts, the FPA is not ratified. It then goes to the Labor Ministry for determination. He asks, what pressure will there be on parties to vote to ratify?
There won't be any pressure put on parties to vote to ratify it as a freely held vote. Now, clearly, the trade union movement, in making a recommendation to its members, would say this is a deal that we have negotiated and got to the end of, and we think you should. And similarly, I imagine the employer's side may well wish to do that and make recommendations, but they can't. That's the only pressure they can apply is moral suasion, or the fact that we think this is the best deal that's actually physically possible. They can't force a vote on that thing. Once you've had two goes of the cherry and it's been lost two times, then it goes to the ERA, because one of the key principles of the fair pay agreements process is that once you have initiated a fair pay agreement, you must end with a fair pay agreement. It can't sit in stasis forever and nothing comes of it at the end. So the ERA will make determinations at the end, but the only power that the bargaining parties have over this is simply recommendatory.
Thank you. Benjamin Clark, who is a great young journalist who's looking at industrial relations increasingly. He's writing about fair pay agreements in Crikey. He's interested to hear about the limitations on the right to strike and how you think this will interrelate with the new industrial relations regime.
The only thing so you've got to be really careful here. You can't strike for an FPA. You can't strike to deliver an FPA. That is a bargained outcome as part of a bargained process. And you can't strike to initiate an FPA. Initiation comes from either the numbers test, you've got the coverage, or the public interest test, and then that's determined. But it doesn't stop industrial action for anything else that is not an FPA, or for any terms and conditions which are part of a secondary agreement, i.e. the collective agreement of an industry that sits over the top of a fair pay agreement. So to give you an example, if you had a teacher's FPA, primary teacher's FPA, and it had common terms and conditions at the bottom, but then you had a collective agreement that sat over the top of that, which included additional breaks or additional training or additional pension payments. If they weren't honoured, or if the union wished to negotiate those, then it can still go to collective industrial action to deliver on those, because they're not part of the FPA, nor are they part of the delivery of the FPA.
So Craig, I think you've referred to this in your presentation, but I think it might be good to clarify for people at home. So Heidi is asking, I understand that fair pay agreements do not replace bargaining as a way of improving wages and conditions. What I'm not clear on then is if an FPA is negotiated and implemented for an industry, can a workplace within that industry that the FPA applies to also negotiate a collective agreement over and above the fair pay agreement terms and conditions?
That's exactly it. You can have whatever you want as long as it's above. So you can the fair pay agreement. I'm British, right? So the fair pay agreement can say the tea must be milky, yeah. But you can go to the employer and say milk's not enough. I demand cream, and it's going to be better. Yeah. So you can have something above that, but what you can't have is something below that. So secondary bargaining can take place on top of a thing, but what it can't do is negotiate terms below the thing. A fair pay is a base upon which you want to build. And that's why it's actually really important for trade unions, because now we've got a solid base upon which we can now negotiate better terms and conditions with employers, safe in the knowledge that actually we're negotiating that base against a common base for every employee in that industry or sector.
That'll be the new catch cry. We want cream. All right, so I think we're coming up to close to time, but there's a few more questions and I don't want to leave too many out. So maybe we'll just go a couple more minutes over if that's all right with you, Craig.
Sure.
Yeah. So Christine, she's really interested in how you think this system will work in the public sector. So a public sector specific kind of analysis.
Sure. So the public sector has a very specific element in this, we have a quite unusual arrangement in New Zealand where we have a public sector, the Public Services Commissioner, who essentially is the person who does all the bargaining for pay in the public services. So it's separated from ministers. So in the core public sector, which excludes some of our health and other people, the Public Services Commissioner will be the person on the other side of the table in terms of at the employer's seat, alongside the departments, and they'll be able to take a cross-government role and a cross-government view in terms of actually how is pay being negotiated for staff in the Ministry of Transport against the Ministry of Primary Industries. But apart from that, it's identical to bargaining elsewhere. There'll be mandatory to agree terms and mandatory to discuss terms. There will be a negotiation, and if there was a fair pay agreement, then it would be subject to ratification of everyone in coverage, not just union members or elsewhere. But because union density in the public sector is much higher, many staff already have collective bargaining. So what we'll end up with in the public sector is likely a fair pay agreement, if we have one, and then collective bargaining on top.
And those trigger tests will already be met because they'll have proportional union membership.
Well, just be really careful on that. It has to be active. So somebody has to actively say, I want a fair pay agreement. You can't simply use your union membership role to say, I have 1,000 members, therefore automatically I can claim. Those 1,000 members have to actively say that they want a fair pay agreement. Well,
I'm glad that I buggered it up so you could make that clear, because it dovetails this last question that's coming from David Dury, who's a leading labour lawyer in Canada. And he's interested in then if you'll anticipate that unions will cooperate in the pursuit of fair pay agreements, or do you expect a lot of competition? Do you think that unions will be vying in the same sectors? And also, how do you see the employer dynamic playing out? Is there a concern that large employers are going to squeeze out the smaller employers?
Well, I would be shocked and appalled at the idea that unions would compete with one another in places. I think that's not the sort of behaviour we want to see. But in all seriousness, unions will have to collaborate, will have to come together. There may well be different union membership in different parts of the country on different things. There may well be if you're going across an industry, then there may well, if you have an industry level sector bargaining or bargaining arrangement, there may well be occupations within that which are represented by different unions. The key thing is that they will form a bargaining side, and they will need to indicate a lead bargaining agent for the purposes of an FPA. So there is one person who's they're able to talk to and say, how about this? But I think the legislation, and certainly the minister, is very keen on seeing unions come together so that they can actually get across the line in terms of initiation, in terms of the numbers, but also come together to make sure that actually they're fairly representing all of their members in terms of the a fair pay agreement when it covers an industry or a sector. Because it may well be that what you don't want to do is to have one group agree to terms and conditions that just benefit them, but which have consequences across the rest of the group under coverage. In terms of businesses, businesses will be required to come together to form, again, much like the trade unions, a bargaining party and a bargaining side. There's an interesting codicil in the law that says if that cannot be found, or the proposal, if that cannot be found, then Business New Zealand, which is the umbrella body for business organizations in New Zealand, will be the default bargaining side. So if no one turns up and nobody wants to be the negotiator, then the umbrella body will become the negotiator by default. So there will always be somebody on the other side. I anticipate that small businesses and large businesses will want to be at the table, because this is very important stuff for them and for some of their comparative advantage. But yes, there is, what happens on the employer side. I think there's a lot of really interesting politics about actually what's going to happen on their side, and we'll have to see how it plays out a little bit here. But I don't foresee those sorts of problems, the sort of problems of squeezing out happening here. A lot of the best employers in New Zealand are actually small employers. They actually already pay the best wages, already look after their staff much better than some of the large employers here.
Well, Craig, those questions came thick and fast. I think you did a fantastic job there. And there's a few I didn't get to, so I'm sorry for those who submitted questions, but we are unfortunately out of time. I will pass on to our communications team at the Australian Institute that they liked the promo work that we did with your headshot. We're going to keep it on file, and we hope that we can talk to you again soon. And yeah, I want to thank you, Craig, for sharing your expertise and your insight. You're clearly very intimately involved in the developments of this policy, and I think it shows just once the ball is rolling, it's a matter of working these things out and advocating for them as you go along. This is, of course, a very live question, important one for us in Australia and across the market economies, when we're looking at how do we emerge out of this period of enterprise bargaining. How do we get the cream? I like this. So thank you for everyone else for tuning in, and for your engagement and for your interest in the work of the Centre for Future Work. If you want to follow our research and our commentaries and our work, you can find it all at futurework.org.au. And keep a lookout for our series, because we'll be sharing more information about the next webinar, and there'll be many more to come. And if you are required to stay home, please do so. Please keep safe and get vaccinated if you can, and stay connected to people you care about. And thanks again to Craig Renney for your time, and thanks for sharing the great word from across the ditch. We appreciate it.
Thank you for inviting me. It's been fun.
Awesome. Okay, cheers everyone. Bye.